Good afternoon, everyone. My name is Steve Merksmer, and I'm a member of the Board of Directors of PPIC, and on behalf of our board and the Institute, welcome to the Bechtel Conference Center for a program featuring the Chief Justice of California, Tani Cantil-Sakauye. Chief Justice, we're very, very pleased you can be with us today. This event is part of PPIC's 2013 Speaker Series on California's future. And I would like to thank the following sponsors of this series for their underwriting support: Applied Materials Foundation, the California Endowment, the James Irvine Foundation, Nicholas Berggruen Institute on Governance, Pacific Life Foundation, S.D. Bechtel Jr. Foundation, Sierra Health Foundation, Southern California Edison, the Stewart Foundation, Union Bank, the William and Flora Hewlett Foundation, and knowledge partner McKinsey & Company. Our series is also funded by PPIC's Donor Circle. Now, before we begin, two brief housekeeping issues. First, prior to leaving today, if you can take a moment to fill out the confidential evaluation survey found in your packet of materials and leave it at the registration table by the exit, it'll be very much appreciated by us and our staff. And second, of course, if you haven't already, please silence your cell phones. Now on to the program, featuring a discussion with the Chief Justice and PPIC President Mark Baldassare about the challenges and opportunities facing the courts as they seek to serve the needs of all Californians. California is indeed fortunate to have an exceptionally skilled, energetic, and dynamic leader of our judicial branch of government. Appointed to the California Supreme Court by Governor Arnold Schwarzenegger and overwhelmingly approved by the voters at the November 2010 election, Chief Justice Cantil-Sakauye was sworn in to office on January 3rd, 2011. She has brought to the Supreme Court her 20 years of distinguished service as a trial court judge and then a justice of the Court of Appeal, as well as the insight she gained regarding the executive and legislative branches while working on Governor George Deukmejian's staff, including serving in the legislative unit and the legal affairs unit of that office. These diverse experiences, coupled with her superior intellect and leadership skills, not to say her charm, make her the ideal leader of our Supreme Court and chair of the Judicial Council of California, which, as most of you know, is the administrative policy-making body of our state courts. So welcome, Chief Justice, and welcome, Mark. We look forward to your conversation today. Thank you.
Thank you, Steve.
Thank you, Steve.
Steve, you did such a wonderful job with the introductions. Thank you so much for joining us today. And Steve does a wonderful job as a board member at PPIC, so it's terrific to have his representation here at this very special event for us. The last time you and I spoke, it was raining. It was a gloomy day in San Francisco. Today the sun's out, so welcome to the Public Policy Institute of California. I have so many questions that I'd like to ask you, and we covered so much ground when we met in person, but I think it would be really valuable for everybody here today if we stepped back and took a broad look at the third branch of government. You are the leader of the third branch of government as the Chief Justice. So for all of us who want to understand how this branch of state government works and what it does, can you give us, from your leadership perspective, what the third branch of government, the judicial branch, does and how it's changed over time?
Thank you, Mark. First, let me say it's a pleasure to be here and have this conversation, to be with the Institute, such a respected and sophisticated organization. I consider it an honor to be asked to speak about the judicial branch. But of course, the judicial branch is the third branch of government, and we serve essentially as a check and a balance on the executive branch and the legislative branch. And our fundamental principle is to uphold and defend the Constitution. So we interpret all laws with an eye toward defending those fundamental principles, upholding that Constitution, and also adhering to the rule of law. Now, we are in a position now as an institution that I like to say we're only 16 years young. Even though the Supreme Court has been around since 1849, the truth is that thanks to the leadership of of several governors, but with the leadership of Chief Justice Ronald George, who built upon the ideas of other Chief Justices, was able to bring about amazing institutional change in the judicial branch, such that we now have something we haven't had 16 years ago, and that is 58 superior courts, 6 courts of appeal, and 1 Supreme Court. We also have state funding. We also have had unification that took over 220 disparate courts and created 58 superior courts, 1 in each county. Also, we have strengthened and built upon the 1927 constitutional amendment creating the Judicial Council. Because as a third branch of government, and while we are 2,000 jurists strong and 18,000 employees covering about 532 buildings and 19 million square feet, and we're the largest in the world, the point is that we are more than a collection of courts. So we have a deliberative body, and that is the Judicial Council. That is our deliberative body that makes decisions serving the public for statewide administration of justice. And I say we're 16 years young because we've had rapid change in the last 16 years to become this institution, but that's given us a fair amount of institutional independence. And what we do, frankly, is we are a centralized, a unified form of branch governance, but we're a hybrid because while we have the deliberative body, the Judicial Council that makes statewide policy for all the courts so that the public has better access, we also share and respect to a great degree local autonomy, which permits the 58 presiding judges of the 58 superior courts to exercise a great deal of independence so they can be answerable and more responsive to their local community. So we have a hybrid. We have what we have really is kind of a perfect tension that we are constantly working on really to better serve the public.
And speaking of constant tensions, in our system of government in California, there's constant tension between the executive branch, the legislative branch, and I'm going to assume the judicial branch. So we've got the Chief Justice, we've got the governor, we've got the leaders of the legislature. Can you give us a sense of where the judicial branch fits in terms of overall government? What do you do? How do you intersect with executive and legislative?
Well, we intersect in a number of ways, but I would generally categorize the way we intersect primarily is through law and through budget. So let me talk about the law. Of course, law is made in California in at least 2 primary ways, and that is by bills that the legislature passes to the governor signed into law, our statutory law, but we also have the development of case law. And those 2 are complementary and also in tension because statutory law may respond and change as a result of case law. So in that way, the executive branch and the legislative branch will, in any instances, if they disagree with a decision of the judicial branch, create statute that speaks directly to those decisions and clarifies that its statute is intended to either codify or disapprove these decisions. So we work collectively on, in some ways, creating the law. But also, and really fundamental to the judicial branch is our democracy only works if, as envisioned by our founders, that no branch can usurp the authority of the other. And so we are in a constant set of tension in ensuring that we check and balance each other. So the judicial branch serves as a check and balance. You know, often we're called anti-majoritarian or counter-majoritarian because the judicial branch decides the cases and the issues before it based on the Constitution, but also the rule of law. And by that, I mean the interpretation of the rule of law or the statute by past decisions. And then we write out our opinions so that you can see where the judicial branch started and where we finished. So everything about our decision making is transparent. And so we don't, unlike the executive branch and the legislative branch, hold hearings and take votes as to what would be the best policy. We don't, as been said before, we don't count noses in the room to find out whether this is a good way to go. We are not majoritarian. We look at the rule of law and the Constitution. We hew to the rule of law while we uphold the constitutional provisions.
And that certainly is different from the legislative approach. So one of the places where we've been reading a lot about the courts in recent years has been around state budget cuts, right? And you've certainly been involved in those discussions at a very high level. And I think it would be useful for all of us to understand when it comes to the courts, what are we talking about in terms of the budget cuts that have happened and that are proposed, and how does that impact the average Californian?
Thank you, and that's a broad question, and I'll try to give you an outline of it and maybe follow up later. But keep in mind that we are the largest judicial branch in the country, probably in the world, and we serve justice to 38 million Californians. And if you were to look at the state general fund pie, how much percent goes to health and human services, how much goes to higher ed, where it goes, if you pull out your microscope, you will find the judicial branch. And we are a 1.2% sliver of the general fund, which amounts to approximately $3 billion for the judicial branch of California. And yet, in the last 5 years, $1 billion has been taken from the judicial branch. And I'll also point out that according to the latest proposed budget, it looks like by our calculations that the judicial branch will receive 1 penny of every dollar of general fund, which I think we come as an incredible bargain given what we provide, and that we interpret and enforce the laws that the legislature and the executive branch have passed to protect you. So we do that without raises, without broadening our scope, with fewer judges, and we do that on 1.2% of the state general fund. So over the last 5 years, $1 billion has been taken. The LAO recently did a graph and showed how much general fund support goes to the branch over the last 5 years, and determined that at least 36% has been reduced from general fund support for the judicial branch. All the while, our caseload remains the same, that when new causes of action are righteously passed to protect you, they come to the judicial branch. And we continue to try to provide justice, a forum for justice, on an ever-shrinking, minuscule slice of the pie. And so what does that mean to Californians? It means disparate access to justice, and in some cases, no access to justice. And I will just give you an example. San Bernardino County, as a result of having to close 3 courthouses in one of the largest counties in the continental US, had to close 3 courthouses. So now, in order for a San Bernardino resident to get his or her day in court, he or she has to travel 175 miles one way to get to court. So you have to assume, A, they have transportation, B, that they can leave work in order to spend the day to fight a matter in court. And then they have a 175-mile round trip back. And that's assuming that the court is able to accommodate them that day, because the court has an ever-burgeoning caseload, fewer judges, and fewer resources. So if that person is employed by a business, that business has to look to doing without that person for the day so that person can enforce his or her rights. This is happening across the state. The formula that keeps coming to my mind as of recent decisions made by the local courts to fit and find their way in this ever-shrinking pie is 10, 7, and 3. Los Angeles has closed 10 superior courts. Los Angeles is a population of 10 million people and over 550 judges. They serve 88 counties and 47 different law enforcement entities. So now we're asking people to drive greater distances in Los Angeles to have their day in court. Like San Bernardino, what we know is people won't come to court, and they will settle those disputes themselves. And we know that has only negative consequences. The 7, Fresno had to close 7 outlying courts. Again, like San Bernardino, a very rural county. What we're basically saying to rural America in California is we can't accommodate you. You need to drive 125 miles one way to the county seat. So we know that based on our reductions that we are facing, we're looking at dismemberment, is my view, dismemberment of a judicial branch. And it's not as simple as if we get money, we can just open up 10 more courts. We would have we'd have other issues to address before we can get there. So we've been talking about the judicial branch budget crisis for the last 2 years, 3 years. But now we think the message has now taken hold of what this really means to your access to justice, what it means to businesses to be able to conduct business and settle disputes and move on, what it means to domestic violence, folks who are looking for protection, what it means to family law when you're looking for custody or change and support, what that really means. And we've been talking about it. We think we have the message, but we need a solution, and we need it soon.
And how do you respond to those who say, well, you know, we have to learn how to live within our means, we've got to create greater efficiencies, or we've got to raise fees on users and things of that sort?
I think that those are all bona fide statements to make, and I don't think you should make those in times of recession. They should always be at the forefront of every day you start with every program. That now is not necessarily the time, but I agree, those are good questions to have. And I would say to that, immediately in 2011, becoming Chief Justice, the first thing I did, and I would have done regardless, is assessed our staffing and assessed whether or not we were serving the right people, the right entities with core priorities. But I always want to say that there is no way that the branch can become so efficient that we don't miss $1 billion out of a 1.2% allocation. There's just no way we can become that efficient, because what we do is we serve the public. So if you mean that we need to reduce, then you need to look at our burgeoning caseloads. We're looking at our caseloads, we're looking at our metrics, we're always trying to find efficiencies. But you can't take $1 billion away and expect that there's going to be the kind of smooth transition and access to justice that you have expected and come to believe, and I think rightfully so, is your birthright.
And as an institute, PPIC knows firsthand all the challenges of remaining independent and impartial in a very political world of Sacramento. And what I'm wondering is, as the leader of the third branch, how do you approach remaining independent and impartial as you are advocating for the kinds of resources that the third branch of government needs in California?
Thank you. That's a great question, because by all appearances, it can look quite political. But let me say first that the Chief Justice of California, whoever he or she may be at any one time, wears 3 hats. There is the hat as the Chief Justice of the Supreme Court, where I sit as an equal amongst my 6 additional members of the Supreme Court, and we focus solely on the case law and the biggest issues facing California. Then there's the hat that I wear as chair of the Judicial Council, which is the constitutional statewide policy-making body of the branch. It's our deliberative body, and it includes a diverse group of folks who consider and decide statewide policy. And then there's the hat I wear as head of the judicial branch, the third branch. But taking the role as chair of the Judicial Council, it is my responsibility and the responsibility of everyone at Judicial Council to advocate for sustained, adequate funding of the judicial branch. And we do that in an administrative way. We do that collectively and collaboratively. And we really, as chief, never does the case law, never does the substantive work that I do as a member of the court ever interfere with that. But I will say that the advocacy of the branch, I would say since 2008, has really changed, because prior to that, our budget was never the subject of attack and never really rated. You know, we had ups and downs like the rest of the state, but never was there anything on scale compared to a $1 billion reduction to the branch. So it required the Judicial Council to sort of take on a new role, one that as judges we're not really equipped to do. We are not politicians. We find ourselves feeling quite uncomfortable when we are walking the halls of the Capitol. But the question became, we have to do it. And in doing so, we had to realize we are acting in our administrative capacity, and our discussion is about budget, and it's not about issues facing the state. And also that assisting us in this advocacy that we find ourselves in has been the lawyers. the lawyers of California, through the State Bar, through Open Courts Coalition, through Bench Bar Coalition and the county bars, BASF, they have been instrumental in helping us with that voice and being in the legislature, advocating our position, making us look less political. I mean, when the Civil Defense Bar joins with the Civil Plaintiffs Bar, and they have the California Chamber of Commerce and CJAC together, I think you begin to realize, if you were to look at the contours of that there is nothing political about this at all. These are people who go after each other tooth and nail in a courtroom. But here they are, arm in arm in the halls of the Capitol. So this is more of a policy issue versus a political issue.
And do you feel like, how's it going this year in terms of being heard from the legislature? The legislature has a lot of new members this year. Is there a lot of educating that you need to do, or do you feel like you're being heard?
Both.
Both.
Feel like we're being heard, but it's always good to educate. It's always good to talk to the new members and try to be a resource for them. They're astute, many of them, in municipality law and municipality policies. And we know that the judicial branch, we went from county funding to state funding. We were 220 courts, now we're 58. We have a little bit of a story to tell, and we like to tell them and be a resource. And they've been receptive, and I'm grateful that they're willing to listen to us and hear us out and find a way to solution.
So let's talk about the fourth branch of government for a moment, which would be the citizens initiative process, something we're very interested in at the Institute. We've been following closely. Every so often there's discussion about reforming the initiative process. That seems to be bubbling to the surface again this year during this legislative session. Occasionally we hear about the court's involvement in the initiative process, and I'd like to hear from you about how do you intersect with the initiative process in California, and from your vantage point, what's working and what's not working about the initiative process?
That's a big question, and I'm going to try to answer as much of it as I can, but I'm happy to take follow-up to speak to what I can about that. I mean, I know that the topic of initiative reform is active and well-meaning, and I understand it, and I know Senator Steinberg, President pro tempore, recently spoke about it in the Chronicle, and we all have personal views, but judges never espouse personal views. So I am going to say to you that the way the Supreme Court intersects, or actually the courts of appeal and the trial court included, the way we intersect with the initiative process, it's almost as if the initiative process strategic plan is to get to the California Supreme Court. Because that's where they all end up. It just seems to me, 6 years on the Court of Appeal, 2 on the Supreme Court. I will tell you in the last 2 years, just off the top of my head, 5 cases have dealt with constitutional amendments have occupied my time. More than 5, I'm sure, but 5 come to mind. So I just want to quote a little bit of my predecessor, the great Chief Justice Ronald George, who talked very freely about the initiative process being a straitjacket, about the initiative process constantly putting our Constitution in such chaos that we'd have a perpetual instability of our California Constitution. And recently, reading from Justice Werdiger's, she delivered a speech to Stanford or Berkeley several years ago, and I was really struck by an amendment in it, or a statement in it, and it said that the United States Constitution, since its ratification in the 1700s, has been amended 17 times, not including the Bill of Rights. So the California Constitution, on the other hand, since its ratification in 1879, has been amended 500 plus times. 500 plus times.
Wow.
And so I asked my folks, how many amendments were on the ballot in November? And I was told 11, and 5 passed. And in the last 10 years, 99 initiatives have been on the ballot, and 39 passed. All of those come to the Supreme Court. And they don't just come once, they come again and again and again, because we will then now interpret some discrete provision or section of the amendment. And of course, we realize this is direct democracy. This is the will of the people. And so it's one thing to say no to the legislature that this is unconstitutional, but we still will say no, this is unconstitutional to the public and the passions that spurred the initiative in the first instance. But we are well aware of it, and we are well aware that 7 justices are looking at something that is emotionally charged and passionately charged, because if it weren't, it wouldn't need to go through the initiative process in California. So we work with the initiatives regularly, often pre-election, post-election, sometimes both. And as you know, they are difficult to, they're dense, they're difficult to interpret, and all the time we start with the presumption of upholding the people's will while hewing to the constitutional and the fundamental principles in the Constitution. It is a monumental task. I think my predecessor called it an occupational hazard for any justice on a high court. I wouldn't go so far. I've only been there 2 years. I can't say that yet, but it's quite a heavy load for the California Supreme Court.
So, you know, pollsters are like chief justices. We don't give our opinions. So I'm not going to ask you an opinion question, but about the initiatives, give me some examples of some, if you could, that really have taken a lot of time and effort to sort through over the last few years. It could be either yours or your predecessor, Chief Justice George.
Thank you. Several come to mind, not only that I've handled, but also just in the history of California. Death penalty twice. Taxes, two-thirds majority opinion, two-thirds to pass a tax in the legislature. Right to privacy, institutional education, marriage, and any permutation of that we've seen in the last several years. Property tax, gill nets. I mean, right?
Okay. So it's a pretty broad group of issues.
Right, and when I think of reapportionment, how many times? At least 2 or 3. I was joking with someone that we've had so many propositions that Prop 8's come around twice now.
That's true.
There was a Prop 8 in the 90s. There's a Prop 8 in the 2000s. So, we lose track, but they come back again and again for good reason, because they're very long, they're very important, they reflect the people's will, and we endeavor to effectuate the people's will at the same time upholding the Constitution.
You mentioned the death penalty in that group. So when you and I spoke a few weeks ago, you talked about all the time and effort that was spent on the death penalty process. Californians are, I would say, very closely divided on the issue of the death penalty. Can you talk to us about the process and how it intersects with your office, and any thoughts you have about how the process of the death penalty is working today?
Thank you. Well, the death penalty is been around for some time now, and remember, there are always 2 aspects to it for the courts, and particularly the California Supreme Court. Not only is there the trial, so it takes years for a capital case to get to trial, and then the trial has another set of rules that overlay the normal rules of criminal procedure because of the severity of the punishment that is potential in a capital case. And they're long, necessarily so. The attorneys and the judge are always very careful in making the record and keeping the record, because all know that not only is this case headed to the California Supreme Court, it will be headed to the federal court and eventually to the United States Supreme Court. So the professionals handle it with great care. They take a long time, they're elaborate, they're important. But once a case has a death verdict at the trial court, immediately they are appealable only to the California Supreme Court. They skip the courts of appeal and they come to the Supreme Court. And at the Supreme Court, we will handle the appellate, the AA, the automatic appeal, and there will also be a habeas corpus petition that is partnered with that AA, not always concurrently or simultaneously. And again, it takes years to develop a record and to perfect the record from the trial courts. But part of the problem we have in California is the dearth of counsel that are qualified to and will take on representation of death cases, either in the appeal or the habeas petition, because they are life cases, they are lifelong cases, because once they move through the California judicial branch, they will inevitably go to the federal judicial branch and eventually to the United States Supreme Court, and quite possibly back and forth to the California judicial branch and the federal judicial branch. So the interplay and the integration of these issues, knowing that they're going to be reviewed by all of these courts and that you have to be thorough and complete so that they don't return to you, means that the professionals are painstakingly careful and accurate and leave no stone unturned. And then, of course, these cases have a life of their own, but over time, they're also influenced by United States Supreme Court cases that hand down rules that affect the case, the death case, as it moves through its appeal and as it moves through its habeas process. So these cases are long, and I mean years long. The court will grant review, well, there'll be review of a case, and it'll be fully briefed, and we won't hear it for years. And I will also say that the numbers are pretty astonishing in California. We have over 700 men on death row who are waiting some stage of process before execution. And in the habeas corpus world, we have about over 300 people, men mostly, waiting for counsel to represent them on a habeas petition. Because a habeas petition requires a different set of skills, because what they're looking at is not what happened on the record in the trial court that may have been error. They're looking at what happened behind the scenes, what wasn't done, and what wasn't done that should have been done. So those are expensive. They will look into the IQ, the developmental disability of someone. Mind you, the person is now 70. The trial was 25 years ago. We're looking into whether that person was developmentally disabled before they were 18, but now they're 70. So the time and effort it takes to go back and get that information, if those records are even available, in order to comply with Atkins, which does not allow a state to execute a developmentally disabled, mentally retarded person, are rules that we all are careful about. It's very, these cases are highly charged. They're very important. They're probably the single most important criminal case that a state deals with. And the Supreme Court has all of them, all the AAs and all the habeas petitions, because unlike other states, the habeas petition in California for a death case starts in the Supreme Court. There's no winnowing of issues. We'll have a claim that is 32 claims on a habeas, and all 32 claims will be examined by the court.
So how exactly does that work, that it's reviewed by the court? Can you walk me through that in terms of does somebody take the lead on that case and do all the investigating and then bring it to everybody else, or how exactly? And then is there, what's the process?
Well, let me start by saying, once we have counsel appointed to an automatic appeal, and counsel briefs the case and files the opening brief, that may take years to file the opening brief. Appellant's opening brief may take years to comply, because they have to perfect the record, make sure the record is complete, and then they have to read the record for error. They have to go through and find out where it is there might be reversible error in the trial court. And these are painstaking professionals. They're very good at what they do, and they look closely at what's transpired in the course of that trial. And then they write their brief. And the brief may have, I'll just say, 20 claims. And once that's briefed, it's previously been assigned to a chamber. So one of the 7 of us will have the case in most instances. And the case will go to our invaluable staff. Each justice has a staff of attorneys, and the staff attorney will take a look at it and write up the facts and write up the issues and some preliminary responses to the issues, and write a draft memo. The justice will review the draft memo and may or may not send it back for further modification or investigation or changing the issues or reframing the issue. And once the justice is satisfied with the memo, he or she will then simultaneously distribute the memo to all the other remaining 6 justices, where they will do the exact same thing. And then when the case is ready, when there are a majority of concurrences, that is 4, on the ultimate memo, we'll set the case for oral argument. And I have cases that I've inherited that are still being worked through that are probably easily 7 years old.
7 years old. My gosh, that is very, very time consuming.
And those are briefed with counsel that represents them. There are other cases out there where we haven't been able to appoint counsel. We can't find counsel, and their case was tried at the trial court decades ago. But we don't have counsel who can then start the record, who can then brief it and bring it to the Supreme Court.
Wow. So that actually explains a lot about why the process is so time consuming. Our institute's gotten very interested in corrections realignment, and part of the discussion around corrections realignment in California has been sentencing reform. And I'm wondering to what degree you and your offices have gotten involved in issues around sentencing reform in California, and maybe it might be worth explaining to our folks here today what's going on there.
Well, sentencing reform in California, it seems to me, has been quite the subject of different pendulum swings, from indeterminate sentencing to determinate sentencing to questioning determinate sentencing to questioning alternatives that are more effective that prevent recidivism. So I would say that there are probably two overarching concepts in California now. And the first is the governor's bill that realigned criminal sentencing such that you have a hybrid sentence now, where certain offenders no longer would go to prison where they normally would, where the judge would have discretion to send the felony offender who was convicted of the felony offense to prison. And the judge is now constrained to dual sentence, county jail time and some community service time or community program time. And this is in an effort to try to rehabilitate the prisoner so that he or she, upon release, has skills where they can be integrated back into the community without reoffending. So it's an effort to try to, I think, improve the lives and give hope to and provide a roadmap for people who can get out of the system given the appropriate skills to become productive members. I will say it's new. It's brand new to the courts. I think we've only really been involved in it in maybe the last year and a half. And so we're still learning our way through consistency and what works best in each county and each judge. Mind you, judges are independently constitutionally elected officers. They still have great discretion. And so we're seeing a variety of practices. We're keeping track of it, and we're seeing what works best. When the governor's legislation was signed into law, we immediately put some of our experts on criminal law and criminal sentencing. We put them to task to say, read this, summarize this, give us best practices, find a way that we can make this understandable and with training to all of our judges, because all of us are facing this. That's one area where, led by the governor, there's a realignment of criminal sentencing. The other area that we're seeing, which is not so much led by the executive branch, but more by the judicial branch and by training, is we're trying to see and move toward evidence-based sentencing. And this is sentencing that is more clearly connected to the offender's symptoms that caused the problem in the first place. So instead of, in the old days, when I was a trial court judge and a person committed a crime, I'd look to the statute, I'd flip open the page, and it would say, if a person commits this crime, there's three choices. You can send him to prison for 2 years, or 3 years, or 4 years. And you picked, and you gave your reasons. Evidence-based sentencing is a bit different. We're looking to provide and order conditions on the offender that will help him or her avoid the problem that got him or her here in the first place. So it requires a little bit more in-depth, investigation and research of the person in a way that we can properly fit a sentence that we hope will be once and for all enough to take them out of the problem that causes them to offend. It's happening nationwide. We're at different stages of it in different courts. It's new. It's different. Judges are used to opening and flipping and saying 2, 3, 4. We all grew up with the triads. We all know what it means to sentence. We all know how to sentence. And this is a radical change away from that.
And where are we in the process of implementing that kind of change?
We have some courts that are in the process. Like I said, this is a perfect example of local control. So we have 58 courts and 58 presiding judges, and each judge has an executive advisory committee that helps that judge make decisions that affect his or her county. And they can create a court that looks at some different kinds of sentencing. They can create an opportunity. Their judges can certainly take this up on their own in terms of how they wish to sentence in this court. And we have training, and we have manuals, and we've learned from our sister states what they're doing. So we're trying to effectuate that. The truth is that the branch has been beset by so many budget reductions. Courts are just scrambling to keep their doors open and trying to make sure we provide access. We'd like to try many different things. We'd like to try ways of delivering justice differently, but in the moment, in the immediate needs, we are faced with budget issues.
So you are so articulate about what the court does and what the judicial branch does. And I am looking forward to the event that you're having next Thursday in Sacramento, the Civic Education Summit. And I'd like to hear from you, how it is that you've become involved in civic education, and what do you hope to get out of this? I know Sandra Day O'Connor is also involved in this too, so maybe it's a national activity as well as state. So tell me where are you going with civic learning and civic education?
Well, civic education is probably one of my passions. It's not connected to being Chief Justice of the California Supreme Court. It's not connected to being Chair of the Judicial Council. Probably, if anything, if I had to tie it to a hat, it's tied to the hat as head of the judicial branch. Because as head of the judicial branch and looking over the, taking the 30,000-foot view of the world of California, my view is that our democracy is strengthened when people understand how it works. And I look at the youth of today, and even really our peers. Maybe they're not, they're not children and they're not in high school, or middle school. But in order to understand and keep our democracy strong and healthy and to perpetuate it, it is my firm belief that we need to educate the world really about the importance of civics and how the branches work and your role and your opportunities as a person who lives in California. I believe that the only way we strengthen it is knowing the interrelationship between the legislative branch, the executive branch, and the judicial branch. All of us want to effectuate change if we can, and it helps to understand the contours of the environment, and that's civics education. So I have questions that come to me that I think the basis of the question is it doesn't understand the predicate of what the branch does versus the other two branches. And our future leaders are in the high schools today. And for the world to be relevant to them, they have to understand it. And so I think that civics education is one of the roads to that understanding. So for example, on February 28th, we're convening an education summit in Sacramento. We're bringing together business, we're bringing together law, we're bringing together the unions, we're bringing together pro bono public legal aid, because we want to bring our collective resources to find a way that we can integrate more civics education into the curriculum. We don't want to tell schools how to do it, but we want to suggest ways that you can integrate examples of government to students as they learn all the other basics, the core curriculum. Let me also say that I've been active in encouraging the law academies throughout California. These are institutions that are placed in high schools as a program where students choose to participate in law and politics and learn about the world around them. And they have retired justices who guide that academy. They have lawyers, they have law professors who come and teach the students in high school, keep them interested, make the world relevant, give them hope about employment outside of traditional jobs they may never have heard of. There are many academies sponsored by the state bar with a lot of community input. And those are the paths to better understanding and appreciating civics and effectuating change in the world to come.
So what do you hope to come out of the summit on next Thursday?
I hope that civics education becomes a well-known platform or initiative, and that we start having the decision makers in California at all levels start to think about ways to integrate it and teach it, so that it's not a surprise, so that in fact we get more than 52.5% of the registered voters turning out. That was the number in the November 2012 election. 52.5% of the registered voters turned out. And I think that if people understood civics education and the value of their vote and how you can make a change in the world, in your community, then if we find a way to talk about that and have it to be a common understood phrase and movement in California, we're a long way toward, I think, healing the state and strengthening the state.
Well, good. There's a lot of other people who are equally concerned about the level of civic engagement. So I think you have a lot of you'll have a lot of allies for that. I am really through all this conversation hearing a vision of what the future courts of California would look like, but I don't quite have it in focus. And maybe you can put it together for me. Where do you hope to take all this in terms of what the courts and what the judicial branch in California might look like in the future?
Thank you. I'm the 28th Chief Justice of California. The judicial branch has been around as long as statehood, and there haven't been very many of us. But I almost bet that all of us chiefs share the same vision. Our aspiration has to be the same. We're defined by who we are. We are the judicial branch. We provide a forum, right? The preamble to the federal Constitution is "We the people to form a more perfect union." The first thing they say is to establish justice. That's the first thing. And so what I would say is my vision is the same as the 27 chiefs before me, and that is to provide equal access to justice. I don't see how that vision could change if you're talking to the 101st Chief Justice of California. But what is different, I think, for each chief are the goals that we find ourselves trying to achieve that vision in the environment in which we lead. So for me, it's easy. In order to achieve justice, my vision is first and foremost, we need a stable, predictable budget that the judicial branch can count on in order to plan and to accommodate and to make public access truly available in all 58 counties, 6 courts of appeal, and the Supreme Court. If we don't have the ability to plan because we don't have the financial ability to count on regular revenue from the state of California, we will always be in an ad hoc scramble to find a way to provide justice. So that's my first goal. My second goal is I have 2 teenage daughters. I know that they spend 90% of their time, if I let them, on technology. That's just what they do. And I like to joke that if John Adams came into the branch today, the only thing different would be the quill versus the pen, because the judicial branch really needs to move into an electronic age. And I'm not saying we're going to be the Jetsons overnight, but I am saying that you need to have access 24/7. You and I know we go to a website, we start clicking away because we expect it to have more depth and more ability than some of them do. The same has to be true of the judicial branch. The attorneys have to be able to e-file. We have to be able to pull up documents and document share and document manage. And it doesn't mean we're putting people out of work. It really means we're reassigning people to do things that probably require more people contact necessarily than filing and submitting a check. We can certainly accommodate that. We have to do that, and that's a cultural change in having judges. My other goal is twofold. Pro bono work needs to be highlighted. We have too much need in California. Legal services are difficult, expensive, and we need to be able to provide services to people to provide access. So we need to talk about pro bono. We need to step up pro bono. And we also need to, I think, clearly encourage greater diversity. California is a majority-minority state, and our population is diverse. It's part of our strength, and I mean culturally, geographically, professionally. We need to have more of an emphasis on diversity in the judicial branch and in the stakeholder groups, the state bar as well. That's the face of 22nd century California.
And all institutions in California are, for the sake of credibility, the work they do, diversity, very important. How are you approaching that in your work?
I approach it very consciously. The Chief Justice has an opportunity to appoint to the Judicial Council. That's mandated by the Constitution, and that's natural and normal because the Chief Justice is accountable to the public, only one of 7 elected statewide. So that's why the Chief Justice chairs and names the council, because when something goes wrong, no one blames the judge in Siskiyou. They blame the Chief Justice, and rightly so. And so what I do in all the appointments, I really seek to find and encourage people to apply because I'm looking for the diversity, because I think it strengthens our decision making. And I speak to law schools and young lawyers about putting their name in, much the same way I was encouraged to put my name in. And I was encouraged to put my name in at the Court of Appeal, and I was encouraged all along. And I want to return that favor.
Fantastic. There are so many other things we could talk about, but I feel like I would be doing a disservice to our guests here today if I didn't ask if there were some questions that might come from the audience. And Chief Justice, thank you so much for really wonderful conversation here today.
Thank you, Mark.
Ted, there's
to concentrate on rehabilitation. Now, I remember from my civics back in high school, another generation ago, that they also talked about punishment. Is that part of the sentencing process also?
It most certainly is. I think part of being able to rehabilitate is knowing what you did, getting punished for it, having buy-in for it as well. We're seeing an attempt, however, to try to curb recidivism, which means maybe a little more emphasis than there has been before on some working tools for some of these folks. But I understand what you're saying, and I was a prosecutor, and I used to argue that punishment came before rehabilitation in the statute.
over here. And we have to go to the microphone
sure.
because for those who are live streaming, and please hold the microphone, Marjorie, for so that there's a kind of an even.
Okay.
So there are people listening live. Stream.
Speaking of prosecution, how does your branch work with the Attorney General's office?
That's a good question. We don't work with the Attorney General's office. They are the entity that represents the district attorney's office, the counties, the public entities that actually petition for review and are advocates in the Supreme Court.
Terrific question. Another reason why civics education needed, huh? Over here.
Thank you, Chief. You did a wonderful job of explaining the problems with the death penalty. I'm wondering if you have a vision about the future of the death penalty in California, if you see these problems simply continuing indefinitely, or if you think there are some solutions.
Thank you. I have been meeting regularly with putting together an ad hoc group of justices in our court and some of our really most knowledgeable staff on the Supreme Court, people who have been there for a long time, who've seen the process, to come together to find a way that we can work internally to find solutions to our process that might be more expedient, that doesn't cost money, because we doubt very seriously that we'll ever get any additional funding to fix the process. So we're looking internally to fix our own where we can. I also meet regularly with the District Attorneys Association and the Defense Council to find out where they think we can become more expedient, where we can collaborate on any kind of idea that we think can continue to provide, to make these cases move through the system, because the defendants have a right to a speedy and timely adjudication, and the victims' families need closure, need an answer. So we've been talking for 2 years. During Prop 34, we talked a little less. As soon as Prop 34 didn't pass, we started up our talks again.
Interesting. There was a question over here, this gentleman.
I came here as a concerned citizen, and I've been very impressed, by your comments. And maybe in terms of education, you've been very articulate. I had no idea the problems, were this interrelated. Maybe you folks on the Supreme Court make a little video like this and pass it out to the high schools and do a step-up thing. Junior high, you learn one thing, step up through the educational process. You have the intellectual talent, you've got the people on staff, and it would begin to teach children about what the implications are for their behavior. And I live in the Western Addition. It's a very mixed neighborhood. We have a huge issue, with gang violence, murders, et cetera, et cetera. Well, some of these kids got that standard curriculum in junior high school. The teacher doesn't necessarily have to know all the intricacies of the law, but you spell it out, and here's what the judge has to say, and this is how it works, and this is what the Constitution is, and these are the reasons why. Straight from the horse's mouth, and then guess what? Maybe, hopefully, some children will start looking at this and start thinking about it at a very young age.
Chief Justice,
Thank you.
I am I always want there to be questions rather than comments, so I'm going to turn the comment into a question. Are you thinking about doing a video? How about that? All right, thank you.
Now I am.
Yeah. Good. Well, actually, we're doing it right now. This is your first. This is a video of sorts that will be available on our website. But maybe it will have classroom applications and maybe something to think of further. Can we have a microphone up here for our guest here? And please hold it because we need the sound to be consistent.
There was an article in the New York Times a couple of weeks ago saying that the number of students applying to law schools has dropped about a third, and law schools are seriously thinking about closing. If you were talking to a young person today who was thinking about going into the law, what kind of advice would you give them?
Great question. That was going to be my last question. So you were like, you were sitting here reading my mind the whole time. Good.
I may be in the minority here, but I think that the world would have fewer problems if there were more lawyers. In the ground up. Sometimes you hear about how boards and commissions and school districts run into trouble. And I think that if someone had law training, they didn't necessarily have to be the California bar. If someone had some training, we could have avoided some issues. I'm saying that's how I view kind of the world. I also think that law school teaches you how to think and how to think critically. Like I say oftentimes, you're not going to remember the elements of negligence, but you need to know where to go to find them. It teaches you how to think. It teaches you how to think about a problem, how to fix it, what resources you can bring to it. And that's invaluable learning. And it is universally useful across many, many disciplines. And law school is 3 to 4 years. And I know it's expensive, and that has to be weighed against the value of being able to go in its use. But some of the most successful people I know don't use their law degree to practice law. They use it to help people, to create foundations. They use it for a myriad of reasons. And it adds a bit of gravitas to the resume, no doubt. But it's a way of thinking, and I think it's invaluable, but it is a personal choice. What I would tell every law student is no job is beneath you. There's something in it for you. Volunteer if you must, but don't say no. Find the best that you can out of it. And some roads lead to untold wealth. I will say that when I started as a lawyer in law school, I took only business classes. But there was a downturn in the economy. I took the first job. It was the district attorney's office. I enjoyed it, didn't know that I would. And then a period of time passed, and the governor's office was looking for a quote-unquote DA type. Well, that was me. And I applied. And from that experience, I learned so much about the executive branch, the legislative branch, from people who were incredible leaders that I would never have had reason to cross paths with before, but I had a law degree that sort of threw me into this, that made another opportunity available, that got me to the bench, frankly, at 31.
So let me follow up on that question and maybe continue on from the bench. For those people who are thinking about a career as a judge, what advice do you have for them?
There's no one path to a judicial position except this. Always, always conduct yourself with great integrity and honesty. No matter what work you do, people will remember your reputation and whether they can trust you and whether you're a person of your word, whether you can be relied upon, whether you show up every day, whether you try your hardest. You may make mistakes, try not to make the same mistake twice, but the point is that it's less about the work you do and more about the kind of person you are. Because in order to be a judge, you are evaluated by the state bar. To become a justice, you are not only evaluated by the state bar, you're evaluated by the Attorney General's office and the Commission on Judicial Appointments. And they look at your work, but they also look at your character.
I can think of no better way to end this discussion today than with those comments. So thank you very much.
Thank you, Mark. I've enjoyed talking to you. Thank you. Thank you.
And thank you to everyone here who joined us today for this very special discussion.